of Bihar.
I'm appearing for the petitioner.
Lord, one thing I would like to point to your lordship. Lord, there is a 3 judges bench order by your lordship. Where in fact, which is not produced in the petition. Lord, if your lordships kindly have a look at this.
Let's kindly.
Your lordships expressed, before you start.
Kindly.
Lord, your lordships expressed a view. Please see, Lord, the order.
Can I have a copy?
Yeah, I'm just giving it. Lord, please see page 2. Page 2. Page 2. In fact, my Lord Justice Anirudh Bose is a party to this. The present petition stands allowed in terms of prayers A, so and so. Now, please read the last line, Lord. This court expects the state of Bihar is not a party before this court is this petition. As such, we make no comment as regards notification issued by the state of Bihar, legality of which have been challenged in this report. But this court expects the state of Bihar shall take into account the judgment of this court delivered on 11th August. Now, Lord, 11th August judgment states you will not consider B.Ed candidates, only D.Ed candidates.
Yes.
Accordingly, though the exam was conducted for everybody, Lord, we have now declared in view of your lordship judgment the results for D.Ed candidates, and we have appointed over 1 lakh candidates, out of which 62,000 have already joined for primary 3. So, state of Bihar has complied, Lord, in accordance with your lordship judgment. This is in fact.
May I now address?
Yes.
Lord, before my petitioner starts, I'm not for the respondent. Lord, this matter was listed before Justice Gopana. Justice Gopana sent it here. Lord, there are several other MAs, 4 MA for clarification, which were listed, if I may pass the order, before a bench of Justice J.K. Maheshwari, and they passed the order that this be listed before the same bench, which had passed the 11th.
What are the MAs for?
MAs are for clarification. Now, what has happened is between 2018 and 2023, because your lordship set aside the notification in 2023, which is of 2018, your lordship said in the nothing about the middle. Now, in various states, various appointments of lakhs of teachers had been made, and various notifications issued, litigations also going on, processes completed, pending. So, what happens? Yes, 4 or 5 MAs. My lord, if I may just pass the order.
Matter pertains state of Bihar. It's confined to state of Bihar. West Bengal is not concerned with this.
It can't be piecemeal. What I'm saying is because various states have come before your lordship may have this order.
See, essentially now the question is whether those who are already appointed,
yes,
will be retained in service or they are working.
Also let's that
Not
the process.
State of Bihar in that main issue is
whether state of Bihar
B.Ed or D.Ed candidates will be considered. That's all. Now, state of Bihar pursuant to your lordship's order of 11th August and the
my learned friend is not pointing out that despite the judgment by your lordships, the state of Bihar during the pendency and despite the orders allowed these appointments to continue, the process to continue.
When were they appointed?
Next, the appointment, the date of advertisement was 10th April and 30th of May of this year. Thereafter, after the exam was conducted by them, allowed to be participated by us after the judgment.
No, were they appointed after the judgment or
No,
before the
no.
judgment?
Let's,
After the judgment,
process
process
was.
But I'll tell your lordships.
Let's kindly consider this.
Lord, the exam notification came in
19,000
September.
19,000
August.
persons, yes, 19,000 persons had been appointed after the High Court judgment. High Court judgment was.
My lords, the
But this is the
Rajasthan.
prayer
Let's
is
kindly,
Why are you?
let's, I'm raising,
Let us crystallize.
That's exactly.
let's, I'm raising three major aspects.
Bihar.
Yes,
I'm exactly on Bihar only, but
Yes.
this is
You
the
said
point
Rajasthan.
here.
Kindly
My lords,
let's
the
permit me.
judgment by which my lords held that it can only be D-led and not B-ed had struck down the NCTE notification, which was Rajasthan High Court, which was on 25th 11/2021. That's
Yes,
a
on the
pan-India
ground.
notification. Wait a minute. That's a pan-India notification because it was a
This is a.
institute notification. Now, once that notification was struck down, and my lords did not say that striking down, no state could have gone and acted upon it, much less Rajasthan, which was a party to this particular matter of the judgment which is
No,
pronounced.
right now we are
Let's,
considering
now Bihar.
Bihar.
Lord, please see the prayer. Please see the prayer. Prayer will indicate
Bihar
everything.
was a party, it had its own.
But where is the question of Rajasthan?
Let's,
Who is for Rajasthan?
Bihar was the party.
Lord, please see Bihar got prayer. Prayers in this.
let's, my petition, now let's kindly
This question is for Bihar.
Bihar, only Bihar.
Issue, because that issue came to be decided on 11th August 2023, and my lords will find in the judgment of this court, one of the writ petitions before this court was arising out of state of Bihar.
Look, I have filed.
That is why let's the order that has been read out.
you want?
That has been complied with today.
Yes.
Therefore, any appointment made appropriately.
That cannot be done.
Yes.
For the judgment.
Your
Will
lord,
not be.
your lordship
The
have
judgment
already
appointment can be
declared
protected or not.
invalid that adjudication. Lord.
So
Lord,
that's why
I'll
I'm
tell you, lordships, not the examination notice. Examination.
What we are going to possibly do, post judgment, no appointment of B.Ed.
Very good.
That's right. That's right.
Pre-judgment, whether here we are concerned with post judgment.
That's right. That's right. Correct. Correct. Correct.
Your lordship have already declared the advertisement invalid. You have to buy the order by your lordship.
No.
One minute, listen, please listen.
Post judgment, here the prayers are for declaration of result. We cannot grant that in view of our judgment. Who are appointed,
It's a different matter
therefore
altogether.
we'll examine whether.
The issue. The issue here.
Yes, the issue is in certain matters.
Or even this
No.
was not then.
This is Bengal. We are dealing with Bihar now.
There are
come
five
to-
states, but what on the.
We are not on that.
Larger issue is.
We are right now confining our inquiry to
Bihar.
post judgment
In Bihar.
appointment.
Yes.
The prayers can't be granted for the simple reason that after this judgment, this would not survive.
Correct.
Review of judgment.
May I now, everybody else except the petitioner has argued the case.
Okay, now you argue, yes.
Let's, the ramifications of the judgment of this honorable court, let's, are vast. The judgment has been rendered by this honorable court on the premise that the decision-making process resulting in the
See,
notification by
right
the.
now, we can't sit on appeal over.
No, let's, I'm not,
Saying judgment.
I'm not, I'm not seeking,
If you ask for review,
I'm not seeking mere lordship.
these reliefs cannot
The
be
ground. There are aspects, let's here, the legitimate expectation, is a doctrine. Let's kindly permit me to complete.
judgment, maybe
Kindly permit me, to complete here.
possibly in that.
Milord, one para kindly see for the same judgment, Milord. This
Already
advertisement has
They
gone
have
by.
seen, they have-
I'll show the entire judgment. Let's
See the one side.
We are on this side or this side?
I am for the delayed condition. This side. This side.
You are appointed. Why are you worried? State is
If you are appointed,
No, Milord.
What? No.
Your lordship have declared the advertisement.
Why are you arguing? But you are appointed.
Yeah.
The advertisement has gone. There is no
I
chance.
go into that issue. I am saying we are only complying with the judgment.
It has been declined.
One minute, no, we are not saying, only the petitioner will hear, no one else.
Let's kindly see.
The state of Bihar, yes.
The advertisement was issued despite the judgment of the Honorable High Court of Judicature at Rajasthan, which was in appeal before your lordships. My rules entitle me for an appointment based on that advertisement. Let me complete. Let me complete.
There is no.
Let me
There has been argued in the main judgment.
let me complete
You
this
are
submission. What I am
a review
submitting.
of this judgment.
No, I am not challenging that judgment. For the reason.
That's what you are saying.
What I am saying is, the process which started.
No, there can't be any protection.
Let's kindly consider this.
Yeah.
My advertisement, I participated in the advertisement
Otherwise,
on the basis of the rules.
we'll dismiss the writ petition.
That's
to the
right.
High Court.
That's right.
Kindly permit me. Kindly permit.
Why have you come to Supreme Court?
Only two aspects. I have filed additional documents.
Not your lordship. Record my statement that we have already complied with and declared the result.
Let me complete it.
Finish.
Yes.
I am not seeking your lordships to relook the judgment in the manner which amounts to sitting in appeal.
Don't in the manner, you don't look at it at all.
Yes, in this case, I have raised a very.
1 minute.
1 minute. Let him.
Why are you arguing? Who are you for?
I am the intervener, my lord. We have 39.
We are not permitting any intervener to argue.
No intervention.
This honorable court, being the apex court, having all the powers, including Article 142, which I am invoking, in the peculiar facts and circumstances of the case, because right to education is a fundamental right created under Act of 2010. Simultaneously with that, what I am saying is this,
Don't stretch it too far.
No, the vacancies, number of vacancies, a right to education, confers a fundamental right on the pupils who are deprived because of the posts not being filled up. There are more than 30,000 posts.
State is saying they fill up all the posts.
The High Court of Judicature at Patna has said, after exhausting their appointment, if still the vacancies remain unfilled, the B.Ed persons can be given a chance. I take it further, on the basis of the policy decision, right in the year 2010, when this act was enacted, the national education policy was being formulated.
All that there's no scope of arguing.
That's right.
For the reason, that policy matters, your lordships, do not interfere in the policy matters.
No,
the policy specifically says, the policy
we don't.
The policy specifically says that slowly by the year 2030, TLED would be abolished. There will not be any course.
There is a judgment of this court that TLED would not.
That judgment, I am trying to impress upon your lordships that judgment does not take into consideration or does not. It does not take into consideration the aspect which deserve to be taken in this writ petition.
No.
On the ground,
You apply for review, we can examine it.
Then kindly keep it pending.
No, we don't keep it pending.
Kindly keep it pending so that the review has been filed by those persons also, which is pending as of now.
We'll see when it comes.
Kindly consider this. Kindly, only 2 minutes more.
So far, you have none of them are on.
Kindly see the rules, on the basis of which
we have struck down the notification.
What these are rules, well, all due respect, the rules didn't fall for consideration. That's why I'm saying devote your lordship judgment. The rules in the state of Bihar mandate this as a criteria. We were eligible under the rules.
Only one petition. How many are
The rules have not been set aside. The rules are still in force. The state today says that it will implement your lordship.
I have challenged the rule. And
That's what part of
that's what I'm saying.
Today, they have challenged
Not a judgment of this court. We that this judgment can't be confronted with the rules of the state. The judgment is
Anyway, let's see.
kindly have it, all the cases on Friday, then along with those applications.
the rules say as per NCT. Once you have struck down the NCT notification,
Plus, kindly see the rules for a minute, my lordship. For a minute, my lordship.
On
Page 433 minutes.
434.
Page 433 minutes.
Rules are categorical.
on 11th August 2023.
Milord, before that, Milord, I want to say one thing.
No. After that.
Similar, there are
No, we are not permitting.
I say let
The writ goes, there are no interveners.
11th August.
Let's kindly consider, let's
Coordinate bench.
let's kindly consider permitting me to, let's withdraw it with liberty to find me.
The order is
One of us
please
is a
don't.
party only. Of which one of us is a party. Had delivered
Let's,
a
may I
judgment.
withdraw it, let's. May I withdraw it, let's, liberty, so that, let's.
Want to withdraw?
Lord, again it will be reopened elsewhere. Lord, again, I tell your lordship,
It is followed.
this matter came up
It
before
is falling from your lordship. I am not saying this.
Conditional withdrawal.
It is falling from your lordships itself, let's, that I can seek review of that judgment which is coming.
No, that's, we are not.
Lordship,
Now the
your lordships. Let's, others also can file review.
If we dismiss, we are not here to advise you.
No, I am not saying that. Let's. I am not
The
saying.
way we dismiss may.
Let's, the remedy of review let's may not be taken away. The remedy of review let's which is available to me in law let's under Article 137.
Not saying anything whether you can file it or not.
Lords, just
Delivered a judgment, striking down the notification.
Let's then all night let's I'll withdraw simpliciter let's whatever it is.
what's happening here is that under different names, there are many
An advocate appearing for the
one
petitioner
here, then another somebody else will file the whole.
submits.
and you won't have an offer. Your lordship may say after arguing for a while, because I'll tell your lordship's why. It came up before Justice Bopanna's bench and I pointed out this order. That is how it has been placed here.
After arguing for a while, learned counsel for the petitioner submits that his clients would not like to proceed with this writ petition. The writ petition is hence dismissed as withdrawn.
Obliged, grateful.
and application also.
Dismiss all applications.
All connected applications
Disposed of accordingly.
shall stand disposed of in view of this
I am grateful.
Obliged.
order.